In California, there are laws that govern your relationship with a real estate agent or broker. Okay, so the law it spells out what your obligations are to your broker or agent, and it also spells out or defines what your broker's responsibilities are to you. Okay, and so when I say broker here, I mean it could apply to either real estate broker or real estate agent, either one. Okay, I'm going to use the term broker, but it also applies to real estate agents. So I want to talk a little bit about how this works in California, the rules that govern the relationship between a client and their real estate broker. And I'm going to just tell you right up front, I don't consider myself to be an expert at this, but I am making an effort to learn more about it for a couple reasons. One is we find that our more and more of our clients are coming to us to ask for help just with real estate questions in general, not just surveying, not just boundary surveying and land title, but other aspects of real estate, because they're just not getting good service from other parties in the real estate profession. So they're coming to us because they trust us. So I'm making an effort to learn more about how real estate works so I can answer those questions. And the other reason that I'm making an effort to learn more about this is we find that oftentimes we're in situations where the real estate agent or real estate broker is not looking out for the best interests of the client. That doesn't happen all the time, but it happens a lot more than we like. And we often get in situations where the real estate broker is trying to talk the client out of a survey, which in most cases I think is a bad idea. So real estate brokers and agents are governed by what we call the laws of agency. Okay, that's why a real estate agent is called an agent, okay, because they're governed by the laws of agency. Okay, now in California, some of those laws are in what we call the civil code. Okay, so just like there's a criminal code that defines what a crime is, what types of crimes there are, and the punishments for crimes. There's what we call the civil code, which describes rules for things that aren't crimes, but that are wrongs. That could be wrongs. They're called torts. So, for example, if your business partner, if you're doing business with somebody and they don't keep up their end of the bargain. Okay, so those are called torts. Okay, and so in California civil code, the state law, there's some rules about what a real estate broker has to do for you. Okay, then we also have what we call the common law or court law or case law. Okay, and those are rules that are made by judges. Okay, as they interpret the law, the judges make rules. Okay, that's called common law or case law. So we have common law and case law about what kind of things real estate brokers have to do, and what they can't do, what they should do and what they can't do. Okay, and then we also have regulation, okay, or administrative law. So in California, the Department of Real Estate administers and oversees, supervises real estate licenses for brokers. Okay, so they have their own set of rules. So in a lot of ways, I shouldn't say that. In that particular way, real estate brokers are like land surveyors, because we also have civil code that we have to follow, case law that we have to follow, and we also have a licensing board with administrative rules that we have to follow. So what kind of laws are there about real estate agency in California? In other words, what kind of things do those laws cover? What aspects of the relationship between a client and their real estate broker does California law cover? All the law, the civil code, the case law, and the regulation. So I'm going to just cover a half a dozen things in this video briefly. I'm just going to give you a quick overview of the types of things that the law talks about when it comes to you and your real estate broker. So the law talks about or defines the type of agency. In other words, what kind of agents there are. Talks about how you create and end or terminate an agency. Talks about how you prove that there was an agency to begin with. It talks about the duties that agents have to their clients, which the law calls a principal. So the duties of agents to principals and principals to their agents. Talks about the types of authority agents can have and spells out when they exceed their authority. And then finally, number 6 is they talk about the liability that agents can have to their principals and the principals can have to their agents. Okay, so I'm going to just cover a couple of those things in this video. We're going to do some more videos on the other aspects, but in this video I'm going to talk about the basic parts of agency under California law. We're going to talk about the type of agents. Okay, So there's 2 or 3 different types of agents. We're going to talk about what they are and then what kind of agent a real estate agent is under the law, what type of agency. Okay, and then we're going to talk about the ways that agencies are created under California law and what type of creation a real estate agency is typically created in. So if you're going to make a person a realtor or a real estate agent, your agent under the law, how does that happen? How should it happen? Okay, so those are the 2 things we're going to talk about. What type of agent is a real estate agent under the law, and how do you create that agency? Okay. So in California law, there are basically 3 types of agents. Okay, so you have what you call general agent, you have special agents, and then you have people that have a power of attorney. Okay, so a general agent is somebody that represents a principal. Okay, represents their client, but it's in a broad scope. So this person has authority to act for the principal in a wide variety of areas. Okay. A special agent is an agent that represents a principal, but with a very narrow scope. So they have authority in only a very narrow a set of circumstances or a narrow scope. Okay. Then you have what's called a power of attorney, and a power of attorney is when you grant an agent kind of special powers, and so they're kind of like they're a supercharged agent. Okay, so as an example, a typical agent, a general agent, or a special agent, they can't sign your name on a legal document and have you bound by it. Okay, but an attorney, in fact, what they call an attorney in fact, or somebody that has power of attorney, they may be able to do that. They may be able to actually sign on your behalf. Okay, so an attorney in fact has some special powers that the other types of agents don't have. So those are the 3 types of agencies in California, 3 types of agents. What type of agent is a real estate agent, typically when you hire them? Okay, they're what we call a special agent. Okay, they have a special agency. So what that means is they have a fairly narrow scope that they represent you in, right? So they're going to represent you in the real estate transaction, right? And they may represent you in some related things like getting the land title insurance or helping you find financing, but they're not going to be representing you. Down at the dry cleaners or in your custody battle. That's not what they're doing. The limited scope, right? It's focused on the real estate transaction that you're trying to execute. Okay, so they are special agents. They operate with narrow scope. Now that is a sword that cuts 2 ways. Okay, because what that means is your real estate agent can't run around doing a bunch of things that they don't have the authority to do that you might not like. So they have a very limited scope, right? So the law limits what they can do for you, right? So we put some pretty strong barriers on the authority that they have to mess your life up. Okay, so that's good. That's good for you as the principal, as the client. Okay, here's the bad part. So 2-edged sword. Remember, the bad part is that means you have to be careful because you may think that something is your real estate agent's job and it isn't, because it's not in their scope under California law. Okay, so for example, we get in situations a lot where a real estate agent is giving the client survey advice, giving the client advice on a boundary survey or land title matter, and the client or the principal is relying on that advice, but that's really not within the real estate agent's scope. It's not within their authority to do that, right? And so if you rely on that information and it doesn't work out in your favor, you might be up a creek without a paddle, so to speak, right? And there's actually some case law where some people have relied on their advice from their real estate agent for something that was kind of outside the scope of their agency, and it didn't turn out well, and they sued their real estate agent, and the judge says, I'm sorry, I'm not going to hold the agent responsible for this bad outcome because this was outside the scope of their agency, right? So you want to be careful about that, 2-edged sword. Okay, so the second thing I wanted to cover was how agency is created in California. So how do you create the situation where you have an agent that represents you and that has some special responsibilities to you under the law? Okay, so there's 4 ways you can do that in California. It can be express. Okay, that just means in writing. It can be implied. That means somebody, by their actions, they act like your agent, and so even though there's not a written agreement, the court's going to treat them like your agent. Okay, one example of this is an actual court case where somebody went to a person that offered real estate financing, and that person told them, I'm going to find you the best deal I can find you. And then they went and got them a loan that paid them a high commission but wasn't the best deal. And that went to court, and the judge said, nah, even though you didn't have a written agreement to be that person's agent, that client's agent, you told them you were going to find them the best deal, and then because you said that and you acted like you were going to do that, I'm going to treat you like you were an agent, even though you didn't have a written contract. So that's implied agency. Okay, then you have what they call ostensible agency, and that's where the principal, or the client doesn't agree to have somebody be their agent, but somebody acts like their agent and a third party relies on that. Okay, so it'd be like if I was selling a piece of property and I had somebody that was acting like my real estate agent and they provided information to a potential buyer, and I acted like that person was my real estate agent and they acted like I was my real estate agent, even though we didn't have an agreement that said they were my agent, a written agreement, but the buyer relied on that relationship, the fact that we pretended like they were an agent. That were to go to court, the judge might say, hey, I'm going to treat Landon and that other person like they had an agency because this third party, this buyer, relied on it. They acted like it and somebody relied on it. That's called ostensible agency. And then finally, the last one is agency by ratification. Okay, and that's where somebody acts like my agent, okay, and I let them act like my agent even though we don't have a written agreement, and then I accept the benefits of their hard work. And then I can't at the end of the deal, when I've got all the benefit, look at that person and say, well, I'm not going to pay you or treat you like my agent because we didn't have a written agreement. So the judge will say, no, Landon, you treated that person like he was your agent. You allowed him to act like your agent. Now you got to pay him like he was your agent. Basically is what it boils down to. Okay, so that's agency by ratification. Okay, now, don't worry if you don't understand all that. We're going to do some more videos about it. Those other types of agencies usually only come up when there's a lawsuit, okay, which is not frequent, thankfully. Okay, so what I want to focus on in this video when it comes to the creation of agency is if you are going to be in a real estate transaction and you are going to be represented by a real estate broker, you want to create that agency with a written contract. Okay, that's called an express agency, right? You don't want to rely on one of these other three ways. Okay, if you're relying on one of those other three ways to create an agency, that means you're in court, right? Or in a legal dispute, a lawsuit. That's not good. Okay, so be smart. Get a written contract, okay, with your agent and understand what's in it, right? Don't sign a contract with a real estate broker that you don't understand. You want to understand what the scope of that broker's agency is, what authority they have, exactly what they're going to do for you, what questions they are going to ask and answer, what questions they aren't going to ask and answer. You need to know all of that, right? So make sure that you understand what they're doing. So there you go. That's how California law governs the relationship between a principal and an agent, in this case a client and their real estate agent, whether the client is a seller or a buyer, right? There's rules that have to be followed, right? So you want to remember, real estate agent is a special agent. They have limited authority. That cuts both ways. And you want to make sure that when you create that agency with your real estate broker, that it's done in writing with a good real estate contract that you can understand.